the application by the state, my lord, I would like to respond as follows. Generally, my lord, the confession in terms of section 217, it's inadmissible against the co-accused. That's the general rule, which is also confirmed in the case of S versus Molimi, 2008, volume 2, SACR 76. It's a constitutional court decision.
Yes, Bankabinde.
Bankabinde, my lord. It's a standard rule, which confirms the provisions of the criminal procedure and the constitutionality of those provisions.
Right.
That the use of a statement against the co-accused is unconstitutional, my lord. In this case, my lord, this honorable court has ruled on the admissibility of the statement that is an issue. And when the state introduced this statement, informed this honorable court that they intended to introduce the statement which was referred to as a confession, and the other one was referred to as a pointing out. And when a ruling, my lord, was made, this court, this honorable court, was guided by the provisions of section 217 and section 219 of the Criminal Procedure Act. And even the proceedings of a trial within a trial proceeded along those applicable provisions of the law. At no stage wherein it was indicated that such statements were the executive statement. And even when the ruling was given, my lord, it was not given that this statement is ruled admissible as an executive statement, because it was not tried as such. And the trial within a trial was not done for the purpose of admissibility of an executive statement. So the submission that has been made by the state, my lord, which I would want to also read because it is contained in the decided case which my learned friends have referred this honorable court to, the case of Mshololo and Nkosi, my lord. It's a constitutional court judgment on page 39. I'll just read the two lines. Yes, ma'am. Common law exception. At common law, there is an exception to the exclusion of extracurricular statement of co-accused if the statement constitutes an executive statement. Close quote, my lord. If the statement constitutes an executive statement. The main issue to be decided, my lord, I submit, by this honorable court, is whether the statement made by accused. Let me not say whether the statement made, because one day it will be said that I said the statement was made. Whether the exhibits, the state, my lord. Oh, yes, the state. They will be saying that, yes. Whether the statements contained in Exhibit GG, Exhibit FF, respectively, before this court, constitute executive statement. If they are no longer the confession, they are now executive statements, then this case is applicable. But if they remain the confession and the pointing out, it means then that this case is misplaced, because the statement that is before this court is not an executive statement. In other words, my lord, the state is doing what is called, or what is referred to as trial by ambush. Introduce a statement as a confession, as a pointing out, then after the state case has been closed, the state makes submissions that such statement be referred to as an executive statement. My lord, there is a difference, a huge difference between the two statements. I will highlight just a few differences between the two statements. Confession is made before a peace officer. Pointing out is made before a peace officer. Executive statement is not made before any peace officer or a magistrate, my lord, in terms of section 217 and 219 respectively. The point I'm trying to make, my lord, is the difference between the two and the circumstances made. Executive statement is not made before a magistrate. It's not made before a peace officer. That's the difference. Then now the statement, my lord, is before this court. Had we been informed from the beginning that these are the executive statements, my lord, the accused person would have defended themselves differently and appropriately. And as a result of the misplacement of this submission, the accused rights to the accused rights to a fair trial has been violated. Even if it has not been violated, my lord, but it will be violated if the court allows the state to use the statements contained in exhibits GG, FF, and HH against the co-accused. Their right to a fair trial will be violated, my lord, and it will render this trial unfair. And also their right to equality will also be violated. As a result, my lord, it is my submission that this court should not allow the state. I don't know the correct term to put, my lord. To allow the state to fish, you know, because the state is now saying it's a confession at the beginning. During the trial, it's an executive statement. Alternatively, it's a statement. It's a hearsay evidence. We're running 3 parallel regimes. And which one do we need to defend? The status of the evidence that is presented before court is very crucial, my lord, so that the accused will be able to defend that evidence appropriately. Even if, because the problem, if that is not defined properly, the classification of evidence that the state is intending to lead, or that the state is leading, is that at the end of the day, the defense will be expected to make submissions on the admissibility of such evidence for the purpose of conviction now. And then if, my lord, the evidence is introduced as a confession, during 174 is introduced as executive statement, then our arguments, it is not clear as to what is it that we need to defend regarding that statement when we are doing the assessment of evidence now, my lord. I submit, my lord, with due respect, that the statement, these 3 statements, as they have been ruled, they do not amount to executive statements. The case of S versus Mshololo, my lord, and S versus Ngozi, it's a constitutional decision case, my lord. My learned friend has referred to it. It's a 2015 well-known case, volume 2, SACR 323. And on paragraph 39, my lord, on paragraph 40 of this case. Open quote, my lord, on paragraph 40. It's a judgment by Theron AJ. It is not necessary to determine this issue. The facts do not arise. The extra crucial statements here were not executive in nature as considered by the state and will not fall under this exception. Determining this matter without any factual metrics to guide our understanding is unnecessary and undesirable. This question was not fully ventilated before us, and we thus have insufficient information to make a determination in this regard. We therefore thank His Lordship for the indulgence given to us so that we'll be able to ventilate this proper, my lord. To be able to make differences, make submissions on the statements that we're talking about. This paragraph, my lord, says, it is not, the exception that the state is referring to is misplaced because the extra crucial statement here that we're talking about now, in this case, my lord, they are not executive in nature. Therefore, the exception is not applicable in this case because the statements that we're talking about, they are not executive in nature. They were not meant under the executive or for the executive purposes and the intention thereof. The state indicated that those 2014 in brackets 2 SACR 431, its application.
Yeah, that's true.
Also, my lord, in my submissions, I also rely on the case of S versus Letting and others, which is also a Western Cape judgment, my lord. It's persuasive to this court, my lord, because it deals also with the constitutionality of the use of a statement made by accused against the co-accused. And it confirms that it is inadmissible. It violates a right to a fair trial of each accused. There is also another one, my lord. S versus Blake, 1844, it's English R, 603, 1844, 6, QB, 126, UK. All these cases, my lord, that I am referring this honorable court to, they confirm, my lord, that the statements made by the accused are inadmissible against the co-accused.
Okay.
The executive statement, just for argument's sake, my lord. These are the statements that are made by a party during the planning or execution of a crime that may be admissible as evidence against the other co-accused. The admissibility, my lord, I submit, the admissibility of that statement, the executive statement, is a complex issue. Although we're not dealing with an executive statement before this court, but I would like to make this submission, my lord. It's a complex issue that depends on specific legal rules regarding hearsay and a fair trial. So in other words, there are laws governing the admissibility of these two statements, my lord, executive statements and statements made under the provisions of section 217 and 219. And it cannot be tried vice versa, my lord. And the usage as well of such statement is governed by the provisions of the Criminal Procedure Act, including the case law that I've referred to this honorable court to. Therefore, they are protected, the usage is protected. You cannot introduce a statement as a confession and then you want it to be admitted as an executive statement. Therefore, my lord, it is my respectful submission that the state should not be allowed to use the statement in exhibits FF, GG, and HH against the co-accused in this matter because they will suffer unfair trial, my lord. Those are my submissions.